M-SPAN brings you long-form public affairs programming within Mayflower, made possible by our sponsors. M-SPAN, easy access to government
Be asked by
matters.
the bailiff to leave. If you don't leave, you'll be held in contempt. If you talk out of turn, and you are a counselor, you will be sanctioned. The last case was a fucking hellstorm of everyone talking over each other, and I actually like to review the arguments made before I make my decision afterwards, and I won't be able to do so if it's all of you talking over each other. So, we'll get to it. Let me just pull up the case information so we can get fully on the record.
Announce the case.
What case is this for?
Sorry?
One moment.
What case is
please.
this for?
Yes?
We are here. One sec. They did not rename the case channel correctly. Un momento, por
Oh,
favor.
it's fine. That's
Your Honor, why is there a random state tourist up here?
This is your last warning to hunt. No, that's the bailiff's problem, not yours or mine. At the moment.
we have 15 bailiffs in the courtroom, so we'll be fine.
I was talking in the VC.
Yeah.
There was one up here. He got moved
Oh.
down, I believe.
Sorry, not sure what happened there.
One moment.
Judge, if you're happy for
One
me to
moment.
announce. Okay.
Oh yeah, you can go for it.
Okay, court's now calling case State of Mayflower versus DanielCrusoe and others. Case number CV37725. Appearances will be required.
Okay. All appearances have been entered. We will now begin. Before we begin to our bench questioning, I will allow each side to present any relevant opening, not arguments, but opening briefs on this matter, starting with the plaintiffs, followed by the respondents. I'll remind both parties, one more time and one last time, that they will both be given due time to respond to each other and due opportunity. Outside of any objections which should not be necessary, I will ask that you don't interrupt each other and that we don't become a little pissing match. Plaintiffs, please, with your opening briefs. You may begin.
I'm not making a opening statement here. I just like to make a notice of supplemental authority in addition to the motion pending or the petition pending.
We can get to that once we get to bench questioning. The respondent.
Okay. Well, it's a notice. It's not a.
Okay, I'll give you an opportunity to give notice. The respondents, any opening brief? Bob, that's you.
Oh,
No,
sorry.
hold on, Your Honor.
was a little distracted.
Hold on. Can everyone hear me? Is this thing fucking...
Yep, I hear something.
Yeah.
Nothing on your end, Bob? Are you trying to...
Am I ready to? Am I allowed to proceed, Your Honor?
Yes,
Your Honor,
you
I
may
think,
make your
Your
opening
Honor,
brief. What is
the
that?
plaintiffs were making a brief. I just think Sado is making a separate point, which he wanted to get on the
I
record.
will entertain Sato's point immediately after opening
No,
brief.
Your Honor. I understand that. I'm saying Sado wasn't speaking for the plaintiff in regards to a brief. He was
Yeah, I'm not
just.
arguing.
I understand.
Yeah.
I understand. My apologies.
Right.
My apologies. Mr.
I don't know if that
or
was.
plaintiffs in general,
I don't
please
know
go
if
ahead.
that was like. You
Mr.
walking
Ball,
down?
I'll ask you to sit down. I'll ask you to sit down. There was a mistake on the court's end. We will rectify that mistake. So, Bob, you will go after. The plaintiffs, please now make your opening briefs.
Right, there we go. Is this thing working? Can you guys hear me, or is it delayed?
We can hear you.
Okay, beautiful. So, in short, let's see. On or about the evening of August 8th, that would have been just about 2 evenings ago, respondents of their own accord convened a meeting for the county board for Clark County, sourcing their ability to do so from Article 3, Section 7 of the Constitution, whereby the state senate, in the event of a defunct county government, assumes the role and the power of the county board. During this meeting, the self-appointed county board appointed a county clerk, DanielCrusoe. The self-appointed chairman of the county board then assumed the role of county executive and was sworn into this role by the sheriff, Bill Tacos. The then appointed county board and county executive adjourned, agreeing to reconvene back in 1 minute. Upon reconvening, the county board then took it upon themselves to appoint and confirm 4 county board members, those being Ashley Pury, Robert Rosenthal, Acudress Walker, and R. Van Teese. The county board then appointed R. Van Teese as their president, with Ashley Pury as their vice president. The county board then took a brief 10-second recess. During said recess, the county executive DanielCrusoe resigned, or the self-appointed county executive DanielCrusoe resigned. When the county board returned from their lightning recess, the county board president, R. Van Teese, was then elevated to the role of county executive, sworn into this office by Sheriff Tacos. Ashley Prairie was then appointed the president. The county board then adjourned, agreeing to reconvene in 1 minute. Passed county resolution number 2025-88, which amended the county charter to expand the authorities of the district attorney. At no point in time was the Senate, who was lawfully conferred the powers as a body of the county board under Article 3, Section 7 of the Mayflower Constitution, was convened. No resolution was put to the Senate, nor any bill tabled onto its docket to amend the county charter, to revive the county board, etc., etc. At no point in time, So that point is moving. Excuse me. So as far as our claim for relief, the writ of quo warranto goes, the Constitution of the state makes it quite clear that the state Senate as a body is the... the state Senate as a body assumes the role of the county board when it's declared defunct. While this may be true, it does not authorize individual senators, i.e. DanielCrusoe, acting of their own accord to act as if they are members of the county board, under which, as an excuse, if you will, the county board was convened. In this respect, the state Senate as a body is authorized to do things that the county board may, i.e. confirm the appointment of county officials such as the chief of police for Lander City Police Department or Mercy Police Department, etc., amend the county charter, and likely enact county ordinances where appropriate, and assume all of the normal functions. In this regard, the state Senate was not convened. There was no resolution, nothing involving the state Senate. Rather, it was the action of one individual senator, that being DanielCrusoe, taking on the role of a county board member and later county executive to unlawfully and illegitimately appoint 4 separate county board members and three separate county board members, now 1 county executive, that being Ashley Prairie, Robert Rosenthal, and Accurate S. Walker, serving currently as county commissioners on the county board, as well as R. Van Teese as a county commissioner. At no point in time was there any election or any sort of democratic process, if you will, honor, that would be required to revive the county government occurred, or was there any other action by the Mayflower Electoral Commission to revive the county government, Your Honor? That was all for our opening statement.
All right, perfect. The respondent may now come up and present his opening statement. You may begin.
Good evening, Your Honor. There are many things to address before the court today, so I'll try to be as...
Sorry, I'll interrupt you once before you begin. Since we are in VC, none of you are required, in VC especially, to call me Your Honor if it's a little too larpy. You can call me Rummy or Judge, whatever you prefer. But you may continue as you wish.
You sound gay.
Your Honor, you sound gay.
You will be held
is what you meant to say.
I will hold you in contempt, Orange. You are going to prison for 2 minutes for misbehaving. Bad boy. Alright, you may continue, Bob.
Alright, thank you. Your Honor, there are many things to address before this court today, so I'll try to be as concise as possible in all my statements. This is a delicate and fragile matter, so I ask in your ruling you take extra care in the application of the law and justice. In response to what the plaintiff has just said, as I stated in my reply, the county's position has changed on that, and we do agree that the actions taken by the senators were against the Constitution at that time. But what we are now challenging, as I said in my reply, is the validity of the county dissolution and the validity of removing the county executive from office. That's all, Your Honor.
Mr. Sato, your notice?
Yeah, just a notice of 2 supplemental authorities, one being Garde versus LCPD, which declared the county government defunct, and then the previous case, obviously, that we just heard, where Judge Singsky said on the record, same thing, pretty much, county government's defunct, and the charter, in addition to that, is not, disbanded, but just defunct. That's all I have to say.
All right, I'm going to ignore the second point of authority, and I'll go into persuasive authority in a moment, and I'll explain why. On the first point of authority, just so I can review it afterwards, I don't know if you submitted a brief before my chambers. But could you link it directly to me, or could you just provide it in DMs and I'll search for it myself?
Yeah, I'll just DM it to you.
Thank you. And for the second point of persuasive authority, which I'll address later on, I'm confused to why the matters in Judge Sinksey's chamber were not enjoined with matters in my chamber, considering that, at least from what I was able to read, both cases are trying to achieve the same thing. Is this?
Can I speak on that?
You directly, just so I can understand what's going on here. Is this an attempt to read the same thing through different judicial instruments? What's going on here?
Are you addressing me?
Yes.
Yeah, so essentially, this case, the only relief that can be granted is quo warranto, which is just challenging their authority to hold the seats. I mean, we technically could get that on the other action, but it's just a related case. I mean, it doesn't necessitate like, what do you call it? Just mitigation of whatever relief can be granted in this case. It's two separate. One is more overarching, and then it applies to the charter at large, and this just applies to them. It specifically targets their validity, their legality to hold seats that they do right now on the Clark County Board.
Your Honor, may I respond to that?
You may respond to this point, yeah. Keep it brief, please, because I don't want this case to become about that.
I don't want this to become like the other one, Your Honor. That was a disgrace of the judiciary, frankly. But I'll go ahead and start. So, Your Honor, in my opinion, they should have been enjoined in the first place. I tried to argue that because if you look at the requested relief for both of them, the only difference is this case is also requesting that they not be recognized as holding their seats. Both of them request an injunction from the defendants to stop their actions and all that. It's almost identical. This one is, I would say, is more encompassing. This just seems like that other case just seems like an attempt to go around the authority of this court, and by the actions of the judge himself, which I will be filing a report for his misconduct in that case. I will, by the actions of that judge, it seems like they were just trying to go around. He let people who weren't even given notice into the courtroom. He ruled that the county charter was inactive based on the other ruling, which said that the county government was inactive under the Constitution and had no bearing over the county charter. He allowed the governor to appoint an opposing counsel
I'm gonna have to cut you off, and I'm gonna explain why.
This is level much.
The way our court structure works is, I can't overrule Zinski. All right, I can't overrule. If you have a matter to bring about the judge in the previous case, any of that, you have to take it with the Supreme Court, not with me. Okay? We're gonna address the matter at hand. I understand your complaints, and I don't find merits on them since I haven't reviewed it, but I would understand if they do exist, your grievances. But we have to address the cases at hand. Now, I've prepared a line of questioning for both sides, so bear with me, and we will get to it. Just so we're clear, I know Bob is probably answering for the respondents. Yes, Bob is answering for the respondents. On the plaintiff's side for bench questions, is Sato or is Britt answering?
I'm only here as like a backup. It's actually
it would be me, Your Honor, Deveris.
Yeah, it'd be Dev.
Yeah, it's me, Deveris Lazar, Your Honor.
All right, perfect. So we're going to start with the main points brought up on the briefs, just so we're clear. Hopefully each side has read each other's briefs, so they're prepared.
We have.
One moment, please. So I will ask now that the petitioner come up. So, Mr. Deveris, to me, this entire case, in a way, seems to hinge on this whole concept of the Clark County government being a defunct entity, right? Now, and I think your own brief points this out, the Mayflower Constitution says that if a legislature fails to meet in 30 days, it's deemed defunct. So my question is this provision in the Constitution, is it self-executing? So what I mean by that, of course, is, does it trigger automatically after 30 days?
Yes, I understand, Your Honor.
Some procedural step.
That is correct. It does. It does trigger automatically. It's just a matter of fact, and it's a matter of law, which is if you just read it, it's a plain text interpretation, Your Honor. The argument that the respondents bring up with regards to lieutenant governors as a procedural defect is neither here nor there. The only thing that the lieutenant governor is responsible for is kickstarting the elections with the Mayflower Electoral Commission. The lieutenant governor himself has no business certifying whether an entity is defunct or not defunct. That's not his role. As a matter of law and as a matter of fact, when a legislature fails to convene, specifically a municipal or county legislature fails to convene, they're just defunct. That's it.
Okay. With the please the plaintiff stay standing. Please keep responses brief because I will be not cross-questioning. I'll be asking you your own set of questions afterwards. I've already read your brief, so please don't readdress brief points. Mr. Bob, anything you'd like to respond to that you think would be that you think
yes, Your
would
Honor.
not? Yeah.
We believe, the county government that is, that the Constitution will not actually specify the lieutenant governor writing his letter to the MEC in that action if it wasn't a necessary procedural step in declaring the county defunct. Because if it is automatically defunct after 30 days, why would the MEC need notice? They would keep track of those things. That's all, Your Honor.
So, yeah, this actually leads perfectly into my second question, Mr. Deveris, which is on the role of the lieutenant governor himself, right? So, I believe this is brought up by the respondent. Article 3, Section 7 points out that the lieutenant governor has to certify the vacancy itself to the MEC. And the respondent here is arguing that it's a mandatory prerequisite, right, to being considered defunct. And, of course, in a way, he's also, like, contesting that it's not self-triggering. So, if this is the case, right, what's your response to challenging that?
So, even if, per se, that the lieutenant... Okay, sorry, let me backtrack a little bit. Hold on. Could you repeat the question, Your Honor?
Yeah, of course. So, the respondents here are pointing out that Article 3, Section 7, or they're claiming, that it requires the lieutenant governor to certify the vacancy with the MEC, right? And they're arguing that this certification is a mandatory prerequisite, right, for the government to be considered defunct. So it's directly challenging, of course, what we reviewed previously, which is that it's not self-triggering, is what they're saying, basically. So if the certification, let's say theoretically, if the certification was mandatory,
right,
and it didn't happen, how could the county government still be considered defunct?
Because at the end of the day, it's self-executing, Your Honor. I'm not going to hit on that point too much. I think the fact of the matter is, well, that the county government, that the lieutenant governor supposedly did not certify the MEC state lieutenant governor / president pro tempore Omni Galaxy did at the time, particularly on November 24th November 19th was the date he did, which was prior to the swearing in of our current lieutenant governor developing new blitz.
Okay, perfect.
So either way, there was a writ of election submitted to the Mayflower Electoral Commission.
Understood.
Your Honor, may I respond?
One moment, Bob. I want to make something clear to both parties, right?
I'm sorry.
What's up?
If I may, for just a moment as well. I'm a little all over the place. You'll have to excuse me. However, the plain text of the Constitution does say, quote, "It shall be deemed defunct." It does not say the lieutenant governor shall deem it defunct and so on and so forth. It just has nothing to do. A government is defunct. It just is, as I've said, as a matter of law and a matter of fact.
All right, and I just want to make something clear before I allow Bob to briefly respond. Since I'm pretty sure either party will appeal, given the constitutional nature of the case, depending on the outcome, of course. We're going every question line by line. If there's a question either party doesn't want to answer, that they feel that they don't have to further clarify their position, apologies. Feel free. Don't feel hesitant to appease the court in a way if there's not something you believe you can meaningfully contribute. Bob, what do you want to respond to that?
Well, Your Honor, I kind of have two branches of points to make on this. The first is we're arguing that it's sort of an implied thing that the lieutenant governor needs to do this as a procedural step for the county to be defunct, because otherwise that clause would just not be there. And second thing, we're also pointing out in the Tilton ruling, which has been brought up in my brief earlier, that the people have a vested interest in maintaining the officers they have in office, right? I know I talked about the holdover rule a lot, and preempting what the opposing counsel is going to say in response to me bringing up the Tilton rule, he's going to claim that the Tilton rule does not apply to the state of Mayflower, and that the standard applied in Lambivanta cannot be applied to the state of Mayflower, because there's no statutory rule requiring holdovers like there was in California and Colorado in those respective cases. But the defense is arguing that this is categorically untrue, with Tilton holding that where the law is silent about holding power, the incumbent remains in office until a successor is qualified to prevent a vacancy and disruption in government. Thus, giving the people a vested right in maintaining their elected officials in government. The defense also cited many cases in our reply, which I feel I must point out. They, unlike Tilton and Lambivanta, they did not actually have a holdover rule like those cases. Those cases I cited, I believe, around 10 cases. 6 of those 10 have been did not involve a holdover rule. We have McCarthy v. Watson, Olson v. Swanberg, Warren v. Christian, Graham v. Lockhart, and Smith v. Tazwell. That's all I have to say, Your Honor.
So before we continue, just in the interest of judicial economy, right, because I, of course, prepared quite an extensive line of questioning here. I'm on the court's own discovery, and please contradict me, well, please correct me if I'm wrong. I've been told that developing nublets, who I believe, and as I'm probably asked to be corrected if I'm wrong, was the lieutenant governor at the time, certified on 4/24/2025 that the city of Lander and the county of Clark to be their county governments to be defunct. What would be your response to this?
First of all, we've received no evidence, and the plaintiff in his own.
Bob? Okay.
I'm asking Bob because he's the one making the initial claim. He's making the argument. Sorry.
We've received no evidence to prove that, Your Honor. No letter, nothing. And additionally, the plaintiff in his application stated that the lieutenant governor did not do it at all. Additionally, that wouldn't apply to the county executive if you rule in favor of the Tilton ruling.
Devers,
Your Honor.
do you have any word on this?
Your Honor, I was just going to add in, I think Devers has a bit of a delay on some of his answers, so I think that's why there's a bit of the awkward pause between response and question. But in regards to the Tilton ruling, just quickly, while I think Dev's throwing out his internet, I would just point out in regard to the precedents, obviously this is coming from a state Supreme Court in comparison to a very clear constitutional precedent in regards to the defunct of power. The ruling would only be applying where the law remains silent. The Constitution is clear, the powers are taken over by the Senate in that instance. So I felt like that was worth addressing, as it was a kind of sub-point which Bob made in his response.
Your Honor, may I quickly reply to that? This is like
Also, again, excusing the delay, Your Honor. Just to circle back to Bob's own point, he did mention that the purpose of the holdover rule is to prevent a lapse in governments and to assume a continuity of government. However, considering that the Constitution itself specifically affords the powers of the county government to the state government to prevent such a lapse in governance, the holdover rule here simply doesn't apply. Because again, the holdover rule, again, by Bob's own admission, is to prevent a lapse in governance. And if there is no lapse in governments due to the roles of the county government being essentially taken over by the state government, it simply cannot apply.
Okay,
May I
so
respond,
before we enter to the holdover, right, because I have a few lines here for the holdover questions. I have a question for Bob, real quick.
Yes, Your Honor.
If a certification did come to be, right, if the court was made aware or if the court discovered through whatever methods we would be able to, that is to be determined, of course, that the lieutenant governor did certify the lieutenant governor did certify the defunct status of the county. Would you be opposed then, or would the would the county's position change in that case that they were defunct?
So we would move that the county legislature may be defunct, and that if you were to rule, in Tilton, because Tilton does establish that the people have a vested interest in maintaining the elected public officials, right? That was one of the biggest things in Lambie, Banta, and Tilton, right? Maintaining their elected officials. So if you were to rule in favor of the county executive, but not in favor of the county legislature, we would move that the Constitution in of itself by the state Senate, authorizing the county executive to appoint people. The remaining board members, the district attorney and the sheriff, could then kind of just revive the county government by appointing people.
But if the county's defunct, what place does the charter have? That's my question.
Well, Your Honor, the county is not. Your Honor, the county itself is not defunct. The actual clauses in the Article 3, Section 7 of the state constitution explicitly state. I want to make sure I quote this correctly. Article 3, Section 7 explicitly state the legislature and the county executive. It does not deem the county charter defunct. It does not say anything else is defunct.
Deborah's, Britt, any arguments on this before we move on to the holdover?
Yes, Your Honor, if I may. The state does not contest.
Your Honor, actually, one quick point.
One moment, Bob, please be quick.
I just want to actually read this. In the event that the legislature of the county or municipality has failed to meet for 30 days, it shall be deemed defunct. It being the legislature being the object of the sentence for it. Sorry, that's all.
Devers?
Yes, Your Honor. The state doesn't contest whether or not the fact that the county charter is defunct, right? At the end of the day, the county charter is still active, right? How otherwise the powers of the county board or county executive wouldn't be conferred upwards to the state. However, that is neither here nor there. Even by the county charter's own admission, by the county charter's own standards, the county board could not have convened under the circumstances in order to make any of this happen to begin with, right? Because at the end of the day, while the sheriff and the district attorney are members of the county board, that is only 2 out of the 3 members required to call a special session as they did. And if you give me one moment, I will get you the citation. It will be section 4-3 Bravo of the county charter, stating that special meetings shall be convened by the county clerk upon the request of the county executive or at least 3 board members. At the end of the day, the county executive in this instance refers to Governor Orange Bear, and he neither requested such a meeting, and there are no 3 county board members to convene such a meeting either. And if I may just briefly on the topic of the precedents being used by Bob, I don't believe that state precedent should be considered, or precedent from state supreme courts, if you will, Your Honor, should be considered in this matter, as this is a constitutional question. And I don't believe that the matters of other states, particularly where a lot of them do have these holdover clauses. In Colorado, I think I noted it is Article 12, Section 11 of the Article 12, Section 1 of the Colorado Constitution has such a holdover clause that we entertain that. At the end of the day, this is a question of what the constitutional interpretation as it is. It has nothing to do with the matter or other states. They aren't binding on our matter here, Your Honor. Hello?
Your Honor?
I'm glad.
Hold on. I'll go check this. Your Honor? Your Honor?
It was a really awkward pause then. was like, what's going on?
Your Honor.
I think maybe okay.
Get me a medic. Get me a medic.
Short recess until he's fixed his Wi-Fi.
Alright.
He just tagged me. Bro, no one reads. No stage, please drag
Yeah,
up.
I can see it. Rummy got timed out somehow. What?
Oh, Rummy was timed out apparently.
Why is he timed out?
I
Can we get a mod to check audit logs?
Yeah, this is
Cool, can you just untime him out?
How can we? Okay, hold on, let's get the medics on.
Bob doesn't have moderator in that.
I'm reading the log. It looks like Bob knocked him out.
Oh, don't even start with Potato. I don't even have moderator.
Okay, well,
Okay,
hold on.
everyone, calm down, let's-
I don't think Anakin has moderator permission, so I wouldn't take his word for it presently.
Cool, Gary.
Cool.
I think Jared.
Grand, beautiful, wonderful. I'll just have to text someone. Okay, can I have everyone?
Oh wait,
Oh, cool.
Coolbury, can you get Rummy back up there?
Alright, already unmuted.
Oh, okay.
Oh, that's strange. He needs to invite to speak. There you go.
Who was so rude to you? Someone arrest.
Everyone, the judge is alive! He's alive! It's
Someone
okay!
arrest Dinobot immediately. Please inform the legislature of Mayflower that we will be going to war with Dinobot. Okay. All right, let's get back to it. Let me turn down my volume on this game because some guy just keeps on putting this helicopter on. Apologies about that, gentlemen. Okay, so I am, if it is a constitutional question, Bob, I am pretty privy to the argument that the holdover clauses don't apply if they aren't explicitly mentioned in our Constitution. Do you have any case law from any of these states where the holdover clause was more inherently interpreted as some sort of common law structure rather than
Actually, yeah, Your Honor. What I said earlier. Sorry, Your Honor, for interrupting you. But what I said earlier, I cited, I believe, 10 additional cases, in which I cited 10 additional cases, in addition to Banta and Tilton, right? And of those 10, 6 of them did not involve. They were all common law. It was interpreted as a common law ruling. The other 4 of them, the constitutions had very vague holdover rules, similar to kind of how our constitution is with the defunct status. But they ruled in favor of Tilton, that the people have a vested interest in maintaining their elected officials, and that the people have a vested interest in maintaining their elected officials.
Okay. So one moment. That's all I need to hear, please. For now, I will. These cases are correctly cited on your brief, right? I'm gonna have to review these extensively, each one. Bob?
Yeah, I believe so.
Okay. If you would be so kind to provide me not right now, but a courtesy copy of those cases afterwards, I'd be much obliged, or else I'll have to search for them myself. In that case, we'll just in case. I haven't decided whether it's relevant yet. But just in case, we'll address some of the holdover questions. So, Mr. Deverous, the respondents are raising here, as you just heard, this common law holdover doctrine as a sort of affirmative defense, and they're arguing that the county executive remained in office because no successor was qualified, or no successor ascended to the office. So how would you guys refute this in the case that the holdover doctrine could potentially apply?
Well, in short,
one more thing. Is there anything in our Constitution that would maybe, besides a lack of mention, outside of a lack of mention, I'll review the other cases that Bob has cited, as I told you. Outside of a lack of mention, is there anything in our Constitution that would prevent the holdover clause from taking effect or being relevant under the laws of our state?
Yes, Your Honor, and quite frankly, it is the very section that is the biggest question of this case, which is Section 7 of Article 3. Now, whereas the holdover clause is specifically designed to prevent a lapse in governance, the Section 7 of Article 3 specifically fixes this issue through conferring those powers to the governor of the state. So the governor of the state assumes the role, assumes the powers of the county executive and all the responsibilities entailed thereof. And so, in essence, the governor, to some effect, becomes that successor, right? It's not that no successor is qualified in this instance. It's just in the interim, until the Mayflower Electoral Commission starts elections, the governor assumes the role of ensuring that the duties of the county executive are discharged appropriately, which, if there were any dispute as to whether or not he was discharging those duties appropriately, that has to do with another case entirely, Your Honor. I believe that.
Your Honor, may we respond?
One moment. I am curious to something. And I think this will help us expeditiously at least answer the question of whether the governor was acting as the county executive. From the time that the county executive no longer existed, does the government have any claim here to state, not claim, any fact to state that the governor was executing the role of county executive in any way?
Yes, Your Honor, and specifically through nominating the the chiefs of the municipal departments, that specifically being MPD and LCPD. That's how he was discharging the duties of the county executive, wherein normally the duty to appoint the heads of municipal police departments would be otherwise conferred to the county executive.
All right.
The governor of the the governor of the executive department ordinarily only has the authority to appoint people directly part of his cabinet, where he sources the ability to appoint the department heads, specifically, as I've noted, the chief of the LCPD and MPD, sources from that role as the county executive, and that's something he's been doing continuously since the county itself was dissolved.
Okay.
Your Honor, may I respond?
What will be your response to this?
Well, the position of the county is that because of the common law holdover, the county executive was actually never absent from office, and therefore the governor has no authority to claim the power of the county executive. Citing the Constitution here, it says, in the event that the executive of any county or municipality has been absent for 30 days, if the common law holdover is to be taken, he will have never been absent from office because he was always ranked in the group. He always had the role, right? And there is a difference between effective absence and like physical absence.
And if I were, Your Honor, then where was the county executive or the county executive that lays claim to this office when there was absences in the various municipal police departments, when there was a need for a county executive to discharge his duty? There was, quite frankly, a political absence. While he may have physically held the office, which he did not according to the Constitution, he was not discharging the duties of his office, right? So in this effect, sure, he can physically sit in the office of the county executive, but unless he actually discharges the duties of the county executive and takes on that role, he has no claim to be the county executive, whereby he has been absent for more than 30 days and hasn't discharged the duty for more than 30 days, which even at the time of his of the dissolution of the county government on November 10 was true.
Well, Your Honor, frankly, I'm sorry, I haven't been recognized, if you'll allow me to respond. Frankly, Your Honor, the county executive was unaware of the common law holdover up until, very recently, and that's why he decided to act in we decided to act in the county board in the way we did, because of the common law holdover. We've seen time and time again people not aware of their constitutional rights becoming aware and then taking action years or decades after whatever happened. So, by virtue of him not being aware, you can't claim that he wasn't acting if he didn't know he still held the office.
So, I feel like we're opening a can of worms here, though, right? If we say that the governor was illegally acting as the county executive, right? Wouldn't that make all the current people who he appointed since that defunct status in office, wouldn't that make them Like, wouldn't you be claiming that they're illegally holding office?
Technically, yes, Your Honor. But we also believe the governor believed he was acting in the he was we also believe the governor believed he was correctly acting under the guise of the Constitution. So I believe in ruling on this matter, we recommend that the county executive be returned to power and all the actions of the governor stay as they are.
Well, that's a conflicting argument, though, right? Sure, I'm not saying that the governor should be sanctioned here. That's not at all what I'm proposing. But you're asking me, essentially, in one of your arguments, to recognize that the governor made these appointments illegally. So, in more practical terms, that these were illegitimate appointments. But at the same time, the argument you're saying is that because the governor thought he was acting in his best interests. Because the governor had no interest. My apologies. All those appointments are valid. That just doesn't sound like too much of a sound legal argument to me. Now, if you don't want to answer it now, that's fine, but I will request supplementary briefs. Hopefully, that you can hopefully get to me before. They can be delivered orally in text chambers. That's fine. But we'll need some supplement on that.
I can provide a quick oral response right now, and then I can probably get some case law to kind of back up what we're saying.
Your Honor, can we just touch on this before we move to this new point regards to the governor's legitimacy of the governor's actions?
Yeah. Wait. 1 second. I want to give Bob a chance, and then immediately, yes. But Bob, please be expeditious. Like 1 minute max.
Well, we're saying this is the most effective way to apply justice in this scenario. I don't remember which it is off the top of my head, but there are instances in case law where people who didn't know they were breaking the law or acted unofficially, right? Their appointments still kind of stood, even though they didn't. Even though what they were doing was technically illegal, and it was in the public interest. Because at the end of the day, what the county is arguing is that it's in the public interest to maintain the elected officials under the common law holdover. So I believe it would be against the public interest, and the courts have continuously ruled in the public interest. So I believe it would be against the public interest to remove all these officials appointed by the governor.
Okay. There's a few arguments. There's like 2 arguments in there at the same time. But Britt, please respond. Don't say whatever you were gonna say. My apologies.
Yeah. So to begin, just quickly, I want to come back to this holdover rule because we're hearing it time and again, kind of beat out by the county, by the district attorney here. We've already addressed its lack of relevance in this case due to the Constitution being explicit in regards to the continuity of government, both in terms of the county executive and the transfer of power to the governor, but also the transfer of power of the county board to the Senate. So there is no lack of continuity in government for the holdover rule to apply under. And if Bob is claiming that he was never inactive from office, then the holdover rule shouldn't apply at all. In regards to the argument of keeping these actions but declaring unlawful, if the court was to take the holdover rule doctrine to be legitimate in this case, which for the reason I've stated I don't believe would be constitutionally sound, but if they chose to, and they were to take the county's view that they should keep the actions of the governor, they'd be essentially looking the other way in regards to their own judgment. They'd be declaring something unlawful and then failing to act according to their own ruling. So while perhaps the county is claiming that it wouldn't be within the public interest, ultimately it wouldn't be in the interest of the rule of law or the integrity of the judiciary for the court to act in such a manner. Or they would be strictly opposed to them making any ruling or such judgment, in regards to upholding the holdover doctrine.
Your Honor, may I quickly respond?
Well, I think I've heard enough on the holdover doctrine for now, Bob. And I have to review the cases you've cited.
Well, I know, but this is just very elementary, Your Honor. It should take no time.
Very brief, and then let's get to the next question, okay?
Yes, Your Honor. So, in response to what he said about the holdover rule being, non-consequential because of the continuous succession, the holdover rule would still apply because effectively the term limit of the county executive would have been over by now. And that's what the holdover rule like more specifically addresses, that he continues to serve past his term limit. So we're claiming that because the Constitution says if he's vacant from office or not active from in office, right? There's no person actively holding that office, then it wouldn't apply, or then it would still apply. I hope I conveyed that. That's all I have to say.
Your Honor, I got the point. I got the point previously, Brett. If you have a response,
I'm just deeply confused by what the county is claiming. So on the one hand, they're claiming that the term is inactive, or not inactive. Sorry, they're claiming that the term of the county executive had expired. Yet he continued to act in that capacity. However, he's also claiming. Well, I'm not done. He's also claiming that there is this transfer of power, and in that case, the holdover rule wouldn't apply. So I was just wondering if he could clarify what is the argument that he's making for this case, not a hypothetical case, like for this case. How is the holdover rule doctrinally relevant within the current case? I'm just a bit confused.
I can do that quite simply, Your Honor. Ordinarily, after the expiration of the term of the county executive, he would, be relieved, right? And there would be no triggering for the constitutional clause, right? But because there was no election, he holds over his term until a successor is chosen, right? We're claiming that the Constitution, it never would have been activated at all if the holdover rule was correctly applied. That's it.
Your Honor, even so, I mean, the point stands that his office was declared defunct not only by the Mayflower Electoral Commission itself, but these courts, these very own courts, from where the Lieutenant Governor, even back in April, performed his constitutional responsibility to submit a writ of election to the Mayflower Electoral Commission, and in an attempt to trigger elections. When, and I know I'm beating a dead horse here, seriously, but the holdover doctrine was designed, as we've discussed, to prevent a lapse in governance. Section 7 of Article 3 of the Constitution specifically confers the power of the county executive to the governor. There is no lapse in governance in this particular scenario, and honestly, the holdover doctrine, by that very logic, cannot apply here, because the governor is fulfilling the role of the county executive. There is no need in this regard, especially when an office is declared defunct, for the governor to remain, for the county executive, specifically that being Arvantes, to remain in office when his role is assumed by the governor. That's all I got, Your Honor.
We're not going to touch on the holdover doctrine for now. Further, I have to go back in the transcript too afterwards, but before anything, we have to find out if this even applies in the first place, right? And then examine the arguments. But I do appreciate the argument being made in advance, so we don't have to do another hearing. Now, one more thing, just for the petitioner, and I will be considering this leads directly next to a line of questioning for Bob. There will be no response here, as I will be asking a relevant question afterwards. Devers. So the petition is alleging that a few rogue senators, right, here took a unilateral decision through, and I quote, to unilaterally bypass all constitutional or feasibly democratic methods. So, while the subsequent appointments, right, that these senators, levied, I guess, did their actions have any legal effect at all, given that the state senate never convened? Or were they just acting, for lack of a better word, playing in the playground with Play-Doh?
So let me start by correcting my facts, because when I did initially apply for the writ, I did mistake. It wasn't a couple of senators. It was one, DanielCrusoe, who was acting under a skewed interpretation of Article 3, Section 7, whereby he assumed that he could take the role of a county boardsman. As a matter of fact, it was DanielCrusoe who was acting as a county boardsman under his skewed interpretation, as at this point in time, the county has already agreed was unlawful, in addition to Bob, the district attorney, and Tacos, the county sheriff, who were acting under the county charter, which confers them seats on the county board. Anyways, where were we? With regards to the actual legal consequence, yes, Your Honor. Because what they effectively did was stand up an entire county legislature, in addition to stand up an entire new county executive, usurping the power in this regard of the state government, and creating a amendment to the creating an amendment to the county charter in order to expand the role and the powers of the district attorney. So yes, there were very real legal consequences here. They stood up an entire county charter, or sorry, not a county charter, a county legislature and a county executive, which under their claim is able to take legitimate actions to govern the people of the county, in addition to already exercising said claim to governance by creating an amendment to the county charter.
Judge, did you hold Kalani in contempt? There's a situation outside.
Bob Kalani, I believe the where is my wonderful Colonel Karm? Colonel, I heard what you said. One moment. Colonel Karm, could you please be dragged up on stage? I believe he's somewhere down there.
Your Honor, I just wanted to clarify. I thought your question was, although what Deveris said is very true, I thought your question was regards to whether or not the actions themselves had legal effect, i.e., does that have any legal kind of meaning? And in that regard, the answer would be no.
One moment. I need to take order back in the courtroom on a separate matter. I do apologize for cutting you off. Albert, who specifically?
We're looking for Kalani 18. Someone's saying that he's been ordered to be held in contempt, and there's a dispute between them and the governor about this.
I think that was in the last case, Albert.
I don't know. Well, someone's currently held up there. So.
Or in game?
Yeah.
Alright. Just bring him forward.
Sorry, everyone. Sorry.
No. So good.
There's your answer, Albert.
You're gonna hold him in contempt or no?
I mean, if I didn't see him do something disorderly in my courtroom, I'm not gonna hold him in contempt.
Okay, that's fine. Thank you, Judge.
Anyways, sorry for cutting you off, Brett. Would you like to resume your point, or would you like me to review it later on the transcript?
I don't mind just quickly
Go ahead.
repeating it. So I'm not sure if I misunderstood you, but it seemed like your question was initially regarding whether or not the senators or the senator's actions and the alleged county executive, county board, etc., whether or not they in their actions had any legal kind of legitimacy as opposed to whether or not
legal legitimacy.
And the answer to that would be no, they wouldn't. A singular senator deciding that he is suddenly the Senate as a whole would have no more legitimacy than me or you deciding that we can suddenly just make a county board. So no, it would be totally illegitimate and would hold no legal legitimacy.
Yeah, I
Your Honor,
may have misunderstood the question, Your Honor. And what I thought you had said is that if the whole debacle had any legal effect as a whole, but I will concede I may have misunderstood.
All right.
Your Honor, may I respond to that?
No,
quickly?
Bob, because we're gonna lead to your line of questioning now, and if you wanna tie it in there, that's fine. But no, not right now.
All right,
Bob. That will be all for now. You will be given the chance to respond the same way Bob did. Deveris, thank you. Bob, please come up. Okay. Memento por favor. We are skipping the holdover arguments. Okay, so let's get back straight to where we were. So you admitted in your brief, I believe, that the appointment made by the senator was invalid, right? So how do I phrase this? Essentially, I feel like, and I don't want to get into the holdover arguments, right? That the claim is being purported up on one leg, which is the holdover, right?
Yes, Your Honor. We're stating. Oh, sorry.
So there's no contest at all, right here, that the appointments of these board members were illegal.
Okay, so Your Honor, what we're stating is because of the holdover, it would have been illegal. But if there were no holdover, it would not have been illegal because the Constitution says they shall take on the role and the responsibility of the legislature. The responsibility of the legislatures of the county legislature is tied up within the county charter. That is very clear in the Constitution, right? Now the Constitution says the county charter says that 5 members may call a special session, and only 3 must be present for the quorum. There were myself, the sheriff, Senator DanielCrusoe, I believe Senator Slexia. It might have been another, and Senator 60 Cry, who called the special session, and it was Senators Daniel Crusoe and 60 Cry who were present at the special session, in addition to myself and the sheriff.
Hold up. And I apologize for getting you off, but I see something being said in here, so I need it addressed.
Oh, and Wooly. Sorry, Wooly.
Were the senators there because they have, or like they would have some secondary role that entitles them to be members of the county board, or were the senators there because they were through the state's authority, right, as legislators, executing or pseudo executing the power of the county board?
Well, because they were state legislators, they would be taking on the responsibility of those board's members.
In that case, how could we even consider holdover in the first place? If the state legislature has a hold up. If a state legislator has authority to sit on a unassigned seat of the county board per se, how could I not find that the governor had the authority in his time to make the appointments he did, and as such there was no vacancy ever?
Sorry, can you rephrase that?
I can rephrase. I apologize. That was a bit of a word salad. If these legislators, right, who weren't elected to the county board, if these you're saying 3, and I'm being told by respondent 1 legislator, by petitioner, if this one legislator, if these 1 to 3 legislators, my apologies, if these 1 to 3 legislators, I hate that word, were executing the authority of the county board due to their position within the state, right? Well, and you're arguing that there was a vacancy when making the holdover argument, and I know we weren't going to go back here, but I think we inevitably led back here. Was Governor Orange not the county executive this whole time?
I think I may have misspoke on my case. I brought up 2 things. One, the validity of the state legislature as acting in the the validity of the legislature acting with the power of the county legislature, and the holdover principle applying to the county executive. So as to, we're arguing that because we were incorrect about the certification, or because of the incorrect status of the certification of the defunct status of the county government, that's why the actions of the senators were illegitimate. Now, if the actions of the senators were not illegitimate, and they were in fact the county, they were in fact part of the, if the actions of the senators were not illegitimate, I'm gonna kind of preemptive thing. One of the issues would be, would they act as one voting block or separate? Because the county charter still says the district attorney and the district attorney and the sheriff are members of the board. So that would kind of allow the district attorney and members of the board to sit on the Senate in aspects relating to like the charter specifically as board members.
Devers, I'll give you a chance to respond.
Yeah, so... Oh, good. Where do we start? As I addressed in my first initial petition, the simple fact is that Section 7 of Article 3 confers to the state Senate as a body, the ability to assume the role of county government. And that has to do with amending the county charter. That has to do with appointing officials of the municipal departments that ordinarily the county legislature. It does not confer to individual senators the ability to act as if they are members of the county board. I mean, it's just a plain text reading of what the Section 7 of Article 3 says. The state senate is conferred the responsibilities. Not senators are conferred the responsibilities of county board commissioners as if they are county board members. It's just it's just a plain text reading, to be quite frank with you, Your Honor. And I can't imagine how, in this regard, respondent has construed the Constitution to say that senators, some of them who may or may not be unsworn, have the ability to act as county board members. Now, even so, right, ignoring that fact, if we just went to the fact that they aren't county board members, then that makes the whole meeting in and of itself entirely null and void, because the county charter requires for quorum at least 3 members moving towards that board. And thank you. Where was I? Sorry, I derailed myself there for just a minute. Right. State senators are not conferred the authority of county board members. We'll just leave it at that. Thank you.
All right.
Your Honor, I was just going to say, but Bob's making numerous arguments here. We've got, it seems like the county doesn't know their own position, or the county doesn't even believe in the arguments they're making, to the point that they have to present numerous different hypothetical arguments to the court, to the point that they're getting confused in their own words and confused in their own arguments that they're trying to make. I just think the court should take it into consideration when considering the merits of the county's case.
Your Honor, may I
I mean, yeah. Please keep it brief since we have more. We have your last lines of questioning. But yeah, go ahead.
So, what the county's point is trying to make is that no matter what road you go down, there has been some, in reference to the legislature, no matter what road you go down, whether if senators have the individual authority, whether it's the Senate as a whole, whether it's there's still, what we're trying to make is, regardless of which avenue you rule on, there is still further things that need to be settled constitutionally and by the charter. Like, does the county board have, does the remaining members of the county board, can they call a meeting with just the Senate in general? Does the Senate have one vote, or do they have all of the votes with the other county board members? We're just trying to point out the fact that something needs to be settled, and that no matter which road you go down, there is still a path to legitimacy through the actions of the individuals, regardless of the steps in between.
Your Honor, the county is... Alright. Your Honor, if I may, the county is creating something out of nothing here, quite frankly. There are no constitutional questions as to the role of the Senate and the county legislature where it concerns Article 3, Section 7. It is very clearly stated that the state Senate is conferred the roles and responsibilities of the county board. And again, I feel like I'm beating a dead horse here, but that does not mean individual senators can assume the role of county board members. What that means is that the Senate is conferred the legislative powers ordinarily given to the county board, to include amending the county charter, to include appointing municipal department heads, to include maybe even enacting county ordinances. Hell, I don't know. However, the point is, Your Honor, the Senate as an entire body assumes the responsibilities and roles of the county government. That does not mean that they can take it upon themselves to act as county board members and to revive the county board, Your Honor. It simply means that the state Senate is now responsible for, as a collective, operating as if they are the county board, to ensure a continuity of government, to appoint municipal heads, to all that shit I talked about, right? As if they are... Yeah, you get the idea. Thank you, Your Honor.
Yeah, I get the idea. We'll leave that at that for now. Continue on to the last line of questioning. Is it still relevant though? I think I've heard enough.
Your Honor, it's not relevant at all.
Order, please. I think I've heard enough for now. I do heavily doubt that any supplementary items will be needed. I'll say right now, I am leaning very heavily towards not recognizing the holdover argument at this time. However, I can't render any decision without reviewing the cases that were cited and there. Of course, seeing how the arguments build in. I have nothing else to see right now. I'll take closing in a moment, of course, and I'm gonna leave this on the transcript since we are, of course, in front of 75 members of the community. It is a little crazy to me. That I'll say it right now, right? No matter where my ruling goes, there is no doubt that the way the Constitution and law is structured, that a single senator can't unilaterally just sit on the board seat because it's vacant, or even with the holdover clause, right? You can't. Those powers are conferred to the state senate as a whole, not to a single senator who can occupy the vacant seat per se. That's all I have to say for now. This seems to be a pretty ridiculous situation. I have to review the case law that was cited to me. We can strike this last part off the record, as all cases that include beloved Attorney General Bonta, I am sure it will be a terrible read, especially if it's in the Ninth Circuit, which I assume it will be. But we will get through it nonetheless. I'll take closing points. No responses will be allotted to either side. I'll take closing points from the petitioner first, followed by the respondent. Before we take any closing points, and please don't bring in anything you would bring in closing, are there any important points that haven't been made in brief or in oral brief through text that either petitioner or respondent would like to make? First, I will ask petitioner.
None that I believe haven't been mentioned, Your Honor. That won't be mentioned again in closing.
Yeah, we don't have anything, Your Honor.
Not at this time, Your Honor.
All right, then petitioner, please present closing.
So, Your Honor, I feel like we've really covered the different arguments here, and I just want to come back to the fundamentals of what we're discussing. In regards to the county board and the power and who has the authority, it's easier to make a timeline. We know that the Lieutenant Governor declared
Whoa. Lieutenant?
Motion to hold them in contempt for being
Oh my god.
Not cool, man. We are a part of the Union of Columbia. Please use proper American English.
Bloody Americans.
Continue, my fault.
Your Honor,
I tell you out on that one. Bob, silent.
the defense is to hold them in contempt for being British.
Alright, so we know that the Lieutenant or Lieutenant Governor sent the necessary documentation to the Electoral Commission, and the argument which was made by the county in that regard is defunct. We know that even if this hadn't occurred, the defunct and transfer of power isn't contingent on this occurring. And the plain text, which I'm sure the court will read and has had read to it numerous times today, is clear on this. In regards to the holdover clause, it's not necessary in this case, because there is no issue in regards to the continuity of government. We have a clear power chain or transfer of power, however you like to word it, continuity, set out within the Constitution as to what happens when the county executive board, etc., is absent for longer than 30 days, and that has been followed, as my friend Devaris brought up, my learned friend brought up. We saw by the governor, Orange Bear, making these appointments. So there is no issue there, and the county has gone to great lengths to try and create an issue that does not exist. The holdover clause is not relevant in this case. In regards to the senators themselves, as the court has already said, and the state 100% agrees, there is no case for claiming that these senators had any form of authority to hold a session. They did not act as a collective, they were a minority of the Senate, unless they had no authority to act in the way that they did. As such, even if this court was to come to the conclusion that a county meeting could be held, which we know is not the case because the county board has already been held defunct, by previous common law, which I know has been discussed at length during this case, the necessary quorum under the county charter has not been met, and therefore the actions within the meeting would also be defunct just on that fact alone. At the end of the day, Your Honour, the county has gone to great lengths to make numerous different arguments to try and confuse the court. The arguments are straightforward and they're clear. There is no legitimate reason or authority for the county to have acted in the way that they did. What has occurred is undermining the authority of the Senate and the executive, and this court cannot allow it to continue. And with that, I yield.
All right. Mr. Bond, would you be so kind?
Yes, Your Honor. So, I'll try to just kind of briefly go over summarize the points in my closing arguments that I've made, just for clarity of argument's sake. As you're well aware, Your Honor, the power of the people is vested, or the power of government is vested in the people, right? As we've made clear several times, the county's position is that in order to the holdover clause isn't just to maintain continuity in government. By keeping elected officials in place, it maintains the people's right to have someone who they elected maintaining their office instead of it going to someone who they elected for a completely different reason, right? 1 second. We've reaffirmed that we're holding the position that the MEC had no right to declare had no statutory right to declare the county defunct, and that's the responsibility of the lieutenant governor under a procedural misstep. And we bring up something that we brought up again, Weiner v. United States, 1958. United States Supreme Court held that removals must follow proper procedures. At this time, I don't think there's anything else that we need to reaffirm that hasn't been said a million times. So.
Very well. Well, if that is the case, we will. I've heard enough arguments. I've hinted towards where I'm leaning right now. So once I've reviewed everything, if there, which I doubt, but if there is a need for supplementary briefs, they will be requested. If not, you can expect a ruling by the morning, or by either the morning or late afternoon EST. I will ask, this is not directed at the parties, this is rather directed at the Chief Judge of the Superior Court on the record. I am aware that there is a matter that has additional relief, but that could lead to a similar outcome as the one of this case. Not a similar outcome, that addresses a direct same matter as the one of this case. As all briefs have already been delivered, I would ask that he convey to the judge presiding on that case to stay the matter till a ruling has been issued by my chambers, as my chambers was the first to, of course, touch the matter per se. Court as such will now be adjourned. Thank you very much, and all of you have a beautiful night. You may actively clown. All right. Finally.
You said that a little strangely there, Your Honor. The first one to touch the matter.
Touch the case.
Oh, buddy. You say no. Nobody touches mine.
You gotta make it weird.
Yeah, this guy puts his territory on it.
Oh, good grief!
Oh, there's some.
By the way, on the matter of the ruling, Your Honor, we expect that to be a written.
I'm getting M-Span back here. There's
it's free.
in the back room.
You said the morning. Can we get that for the British Standard Time?
That will be your early afternoon, late afternoon.
That'll be in like 12 hours for you.
It's like 3 a.m. now, so...
It'll be in 12 hours for you at the latest.
Okay.
Or
that'll be like around dinner time.
Around
for the
like
record as well, Your Honor, is a written ruling going to be delivered?
Of course. Look, it's obvious that this is most likely going to get appealed, right? Like, either I'm very confident here